Hi, this is Keith Preston, the attorney here at Preston Law Office. The topic of today's video is what effect does changing the name on the tax assessor, tax collector records have upon the ownership or the title of property? This is going to be a really short video today because I can tell you that changing the name on the tax assessor records has absolutely no effect upon the ownership of property. I have people come to me from time to time. We'll be talking about changing the title to property that was owned by the mother or father or whoever is now deceased, and they'll say, oh, I've already taken care of that. I took the death certificate up to the tax assessor's office and they assessed the property in my name, and they'll show me a document showing that it's assessed in their name. And they'll say, see, I don't have to probate the will. Well, unfortunately, that does nothing as far as the ownership of the property goes. It does mean that you'll get the tax bill and it will have your name on it, but you will not be able to sell that property. You will not be able to borrow money on that property. You don't own that property. Really, the tax assessor is not supposed to change the record under those circumstances by just showing a death certificate, but I can tell you that it happens because I've seen it a number of times. What you have to do in this instance, you have to open an estate. If there was a will, you open an estate. If there was no will, you open what's called an administration, which is basically an estate where there's no will. Everything will be determined by the intestate statute. Once you have that estate or that administration open and it is time for the assets of that estate or administration to be distributed, you will have to then write a deed. Whoever the executrix or administrator of the estate is, they will have to sign an administrator's deed, an executor's deed, and deed the property from the estate of the person to whoever it's going to. Whether it's one child or equally among all the children, whatever the case, there has to be a deed in order to transfer the title of that property. This is really an issue that needs to be addressed as soon as possible after the need is recognized. I have had several situations where a family has come to me where there's been a generation that has simply been living in the property, having it assessed in the name of the heirs of the mother or the father, and they're wanting to sell the property or to borrow money on it or something of that nature, and have been told that they don't own the property, which is correct. They can own the property. They're the rightful heirs that should be able to own the property, but they don't own it. The longer you wait trying to resolve a situation like this, the more complicated it's going to be, especially in the case of where it is an estate where things are passing to the children. If there are multiple children and one of those children dies, but that child had children, everything that the original child would have gotten is going to be split equally among his children. I've had situations where we've had a child die, had a child of the child die, and then we get into grandkids, and it just keeps getting larger and larger. The pool of people that we have to deal with just keeps getting larger and larger, and sometimes because of the family spreading out and because it's been a long time, these people may not even know each other, and it can become difficult to get everybody to cooperate and to understand what's going on and to do what needs to be done. I hope this video has been of some use to you. I'd be glad to discuss these matters with you further. You can contact me at the phone number and email address that appear on this video. Thanks for watching the video, and thanks for visiting PrestonLawOffice.com.